All rise.
Thank you, Sheriff. You all may be seated. Mr. Lewis, Ms. Madsen, it's my understanding both sides have rested and closed. Is that right?
Yes, sir.
Very good. Thank you. You all may be seated. Members of the jury, as we talked about during jury selection and perhaps alluded to at some point during this process, after you hear all of the evidence that you're going to hear in this case, then the next thing that will happen is that I will deliver to you the jury charge. The law requires that I read it word for word. You will have this copy to take back with you during your deliberations. It does contain all of the law that is necessary to enable you to reach a verdict. You will see that the structure of the jury charge is basically, it contains the charge, contains some applicable law, those definitions, those terms of art that we heard in jury selection, that we've heard throughout this trial. If a word is not defined in our law, then you use your common ordinary understanding of that word. Do not, under any circumstances, appeal to another source of authority, a dictionary, a Google, or anything like that. You're not supposed to have or be looking at any of those things during deliberations. The jury charge is approximately 11 pages. On page 12 contains the verdict form. The verdicts are mutually exclusive. And then there is a note form for you to use if you need to communicate with the court, as well as a request for testimony to read back to you. I'll get to that at the end. Jury charge reads as follows. Cause number F1700545, the State of Texas versus Christopher Hess. Members of the jury. The defendant, Christopher Hess, stands charged by indictment with the offense of aggravated assault by a public servant, alleged to have been committed on or about January the 18th of 2017 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. Your verdict must be by a unanimous vote of all members of the jury. In deliberating this case, you shall consider these written instructions as a whole, and you must not refer to, consider, or discuss any matters not in evidence before you. Do not let bias, sympathy, or prejudice play any part in your deliberation. Applicable law. Number 1. Person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the person commits assault and the person 1. Causes serious bodily injury to another, or uses or exhibits a deadly weapon during the commission of the assault. A person commits the offense of aggravated assault by a public servant if the person commits aggravated assault and the offense is committed by a public servant acting under color of the servant's office or employment. Page 2. 1.1 definitions. You are instructed that, as used in the law applicable to this case, the following terms have the following definitions. Person means an individual. An individual means a human being who is alive. Another means a person other than the actor. Actor means a person whose criminal responsibility is in issue in a criminal action. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A deadly weapon is a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Public servant means a person elected, selected, appointed, employed, or otherwise designated as an officer, employee, or agent of government. Government means the state of Texas, a county, a municipality, or political subdivision of the state of Texas, or any branch or agency of the state, a county, municipality, or political subdivision. 1.2 mental state definitions. A person acts intentionally with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly with respect to the result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Page 3. A person acts recklessly with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary and prudent person would exercise under all the circumstances as viewed from the actor's standpoint. Number 2, application, charged offense. Now, Bearing in mind the foregoing instructions, if you unanimously find from the evidence, beyond a reasonable doubt, that on or about January the 18th, 2017 in Dallas County, Texas, number 1, Christopher Hess, hereinafter called the defendant, intentionally, knowingly, or recklessly caused bodily injury to another, namely Genevive Dawes, hereinafter called complainant, by shooting the complainant with a firearm, a deadly weapon. 2, and the defendant either A, caused serious bodily injury to the complainant, or B, used or exhibited a deadly weapon, namely a firearm, during the commission of the assault. And 3, the defendant was then and there a public servant, namely a City of Dallas police officer acting under color of his office and employment. Then you will have found that the defendant committed the offense of aggravated assault by a public servant as charged in the indictment, and you will next consider whether the defendant's conduct was justified as explained below. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant not guilty and say so on the verdict form. Number 3, justification. If you have unanimously found beyond a reasonable doubt that the defendant committed the offense of aggravated assault by a public servant, you must next consider, page 4, whether the defendant's conduct was justified as 1, deadly force in self-defense, 2, deadly force in defense of a third person, or 3, deadly force by a peace officer making an arrest. It is a defense to prosecution that the conduct in question was justified. You are instructed that a reasonable doubt on the issue of justification requires that the defendant be acquitted. The defendant is not required to prove that his conduct was justified. Rather, the state must prove beyond a reasonable doubt that the justification does not apply to the defendant's conduct. In addition to the definitions already given, the following definitions apply to the issue of justification. Number 1, reasonable belief means a belief that would be held by an ordinary and prudent man in the same circumstances as the actor. Deadly force means force that is intended or known by the actor to cause, or in the manner of its use or its intended use is capable of causing death or serious bodily injury. Unlawful means criminal or tortious, or both, and includes what would be criminal or tortious, but for a defense not amount to justification or privilege. The term peace officer includes a police officer of an incorporated city, town, or village. 3.1, deadly force in self-defense. A person is justified in using deadly force against another. Number 1, if the actor would be justified in using force against the other, and 2, when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. Page 5. Person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. A person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force as described by this section, and you may not consider whether such a person failed to retreat in determining whether the actor reasonably believed that the use of deadly force was necessary. Now, bearing in mind all the foregoing definitions and instructions, if you unanimously find from the evidence beyond a reasonable doubt that the defendant committed aggravated assault by a public servant as charged in the indictment, but you further find from the evidence, or have a reasonable doubt thereof, that 1, the defendant reasonably believed the force, when and to the degree used, was immediately necessary to protect himself against the use or attempted use of unlawful force by Genevive Dawes, and 2, the defendant reasonably believed that deadly force, when and to the degree used, was immediately necessary to protect himself against the use or attempted use of unlawful deadly force by Genevieve Dawes, then you will find the defendant not guilty, and so say on your verdict form. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force in self-defense, and you will next consider the justification of deadly force in defense of a third person. 3.2, deadly force in defense of a third person. A person is justified in using deadly force against another to protect a third person if, 1, under the circumstances, as the actor reasonably believes them to be, the actor would be justified in using deadly force to protect himself against, page 6, the unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect, and 2, the actor reasonably believes that his intervention is immediately necessary to protect the third person. Now, bearing in mind all the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that the defendant committed aggravated assault by a public servant as charged in the indictment, But you further find from the evidence, or have a reasonable doubt thereof, that 1, under the circumstances, as the defendant reasonably believed them to be, the defendant would have been justified in using deadly force to protect himself against the use or attempted use of unlawful deadly force by Genevive Dawes that he reasonably believed to be threatening Jason Kimple or Zach Hopkins, and 2, the defendant reasonably believed that his intervention was immediately necessary to protect Jason Kimple or Zach Hopkins, then you will find the defendant not guilty and say so on the verdict form. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force in defense of a third person, and you will next consider the justification of deadly force by a peace officer making an arrest. 3.3. Deadly force by a peace officer making an arrest. A peace officer is justified in using force against another when and to the degree the actor reasonably believes that the force is immediately necessary to make an arrest if 1. The actor reasonably believes the arrest is lawful, and 2. Before using force, the actor manifests his purpose to arrest and identifies himself as a peace officer unless he reasonably believes his purpose and identity are already known by or cannot reasonably be made known to the person to be arrested. Peace officer is further justified in using deadly force against another when and to the degree the peace officer reasonably believes the deadly force is immediately, page 7, necessary to make an arrest if the use of force would have been justified as described above, and, number 1, the actor reasonably believes the conduct for which arrest is authorized included the use or attempted use of deadly force, or 2, the actor reasonably believes that there is a substantial risk that the person to be arrested will cause death or serious bodily injury to the actor or another if the arrest is delayed. There is no duty to retreat before using deadly force justified in this manner. Now, bearing in mind the foregoing instructions and definitions, if you unanimously find from the evidence beyond a reasonable doubt that the defendant committed aggravated assault by a public servant, as charged in the indictment, but you further find from the evidence, or have a reasonable doubt thereof, that, number 1, the defendant was a peace officer, and, number 2, the defendant reasonably believed deadly force when and to the degree used was immediately necessary to make an arrest, and the defendant reasonably believed the arrest was lawful, number 4, and the defendant, before using deadly force, either A, manifested his purpose to arrest and identified himself as a peace officer, or B, reasonably believed that his purpose and identity were already known by or could not reasonably be made known to the person to be arrested. 5, and the defendant reasonably believed either the conduct for which arrest was authorized included the use or attempted use of deadly force, or B, there was a substantial risk that the person to be arrested would cause death or serious bodily injury to the defendant or another if the arrest were delayed, then you will find the defendant not guilty, and so say on the verdict form, page 8. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force by a peace officer making arrest, and find the defendant guilty of aggravated assault by a public servant as charged in the indictment, and so say on the verdict form. Presumption of innocence and burden of proof. All persons are presumed to be innocent. No person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. In all criminal cases, the burden of proof is on the state. The state has the burden of proving each and every element of the offense beyond a reasonable doubt. The state is not required to prove that a person is guilty beyond all doubt. The state must simply exclude all reasonable doubt about the person's guilt. If it fails to do so, you must acquit the defendant. Number 5, evidentiary instructions. The indictment in this case is no evidence whatsoever of the guilt of the defendant. It is a mere pleading necessary in order to bring this case into court for trial, and you will consider it for no other purpose. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. You are not to be concerned with the reasons for such rulings and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question, page 9, of law. In admitting evidence to which an objection is made, the court neither determines what weight should be given such evidence nor passes on the credibility of the witnesses. As to any offer of evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any act or word to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it. Our law provides that evidence of a crime, wrong, or other act is not admissible to prove the person's character in order to show that on a particular occasion the person acted in accordance with the character. In this case, evidence has been admitted that Genevive Dawes and Virgilio Rosales may have committed crimes, wrongs, or bad acts. You were instructed that this evidence was admitted only for the purpose of showing the possible motive of Genevive Dawes. You may not consider this evidence for any purpose unless you find and believe beyond a reasonable doubt that Genevive Dawes and Virgilio Rosales committed the crimes, wrongs, or acts alleged. Even then, you may only consider it for the purpose of determining the possible motive of Genevive Dawes, and you may not consider it for any other purpose. Hearsay is a statement that, 1, the declarant does not make while testifying at the current trial or hearing, and 2, a party offers in evidence to prove the truth of the matter asserted in the statement. Hearsay normally is not admissible. In this case, certain hearsay information contained in records that were reviewed by expert witnesses was, page 10, admitted before you through their testimony. Such hearsay was admitted only for the purpose of showing the bases of the witness's opinions and cannot be considered as evidence to prove the truth of the matters asserted in the hearsay. Number 6, right not to testify. Every defendant has the constitutional right to remain silent. A defendant may testify in his own behalf if he elects to do so, but this is a privilege, and if he chooses not to testify, that fact cannot be held against him. In this case, the defendant has elected not to testify, and you are instructed that you must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Deliberations and verdict. Following the arguments of counsel, you will retire to consider your verdict. After you retire to the jury room, you will select one of your members as the presiding juror. It is the duty of the presiding juror to preside over your deliberations, to vote with you, and when you have unanimously agreed upon a verdict, to sign the verdict form accordingly. Your sole duty at this time is to determine whether the defendant is guilty or not guilty as charged in the indictment in this cause, and restrict your deliberations solely to the issue of whether the defendant is guilty or not guilty. During your deliberations, if you need to communicate with the court, please press the red jury call button and the bailiff will respond. Your communication with the court must be in writing through the bailiff and signed by the presiding juror. A suitable form for communicating with the court is attached to this charge after the verdict form. The court will answer any such communication in writing. No one else has any authority to communicate with you during your deliberations. Do not attempt to talk to the bailiff or the attorneys regarding any question you may have regarding the evidence, page 11. During your deliberations, you are entitled to view any or all exhibits admitted as evidence in this case. You may not have any testimony from the trial read back to you unless you are in disagreement about a specific statement or testimony of a witness. If during your deliberations you disagree among yourselves about the statement, testimony of a witness, you may ask the court to have the testimony about which you disagree read back to you from the court reporter's notes. A suitable form for requesting that testimony be read back to you is attached to this charge after the verdict form. It is only from the witness stand you are permitted to receive evidence regarding this case. You should neither consider nor mention any personal knowledge or information you may have about any fact or person connected with this case that is not shown to you by the evidence. You are not to use any other means or device to communicate about or research any issues in this case. You are the exclusive judges of the facts, the credibility of the witnesses, and the weight to be given their testimony, but you're bound to receive the law from the court which is given in this charge and to be governed thereby. The credibility of the witnesses and the resolutions of any conflicts in testimony are fact issues to be resolved by you, the jury. A suitable form for your verdict is attached. Once you have reached a unanimous verdict, fill out the appropriate verdict on the verdict form and then press the red jury call button. Signed on this, the 11th day of February 2020 by me, Brandon Birmingham, judge of the 292nd. Page 12, the next page would be page 12, but it says page 1 of 1 is the verdict form. Reads as follows. Cause number F17-00545. State of Texas versus Christopher Hess here in the 292nd Judicial District Court. Verdict form. We, the jury, unanimously find the defendant guilty of aggravated assault by a public servant as charged in the indictment, and there's a spot for the presiding juror to sign and print his or her name, should that conform to your unanimous verdict. Or, and these verdicts are mutually exclusive, we, the jury, find the defendant not guilty, and there's a spot for the presiding juror to sign and print his or her name. The next page is communication with the court. That's a form that you can use if you need to communicate with the court. If you have more than one note, feel free to use a sheet of notebook paper that Sheriff Martin will be providing to you. You can use that too. And the last page is a request for testimony to be read back. The law does not allow a rereading of testimony. Should you have a dispute, you need to delineate that dispute, and this is a good way to do it. If you have more than one dispute, you can use a different sheet of paper. However, the words on the different sheet of paper would need to reflect that dispute. Once we receive that, if you have it, it takes a little bit of time to get it back to you, but we'll go as quickly as they can. Since the state has the burden of proving their case to you, they get to open the arguments. It is my understanding that Mr. Mitchell is going to open the arguments.